Hello and welcome to Business Today Television. I'm Siddharth Zarabi and you're watching Easynomics. The Parliamentary Standing Committee on Finance has made groundbreaking suggestions on India's competition law as well as recommendations for making sure that there is fair play and uniformity as far as India's digital economy is concerned. And joining me to discuss those groundbreaking recommendations is the chairperson of the Parliamentary Standing Committee on Finance, former minister and present member of the Lok Sabha, Mr. Jayant Sinha. Mr. Sinha, welcome to Business Today Television. Thank you for your time. Since there are a number of key recommendations that you have made, I want to break it down for our viewers, starting first with the competition amendment proposals that you have made, and we'll then come to the digital part. The key recommendations on the competition law side that you have made, Mr. Sinha.
Thank you very much, Siddharth, and great to be with you and with your viewers. Competition law in India is going to undergo a sea change. And to understand what is happening, recognize first that the government introduced a competition amendment bill after 15 years. So competition law was substantially amended in 2007. But thereafter, for 15 years, there weren't any further amendments to the competition law in India. So that is a very important set of amendments that the government brought, and we, of course, as a committee have worked on that and provided our recommendations on it. Second, the Standing Committee on Finance has also introduced a digital competition report looking at digital markets specifically and providing some recommendations on how we can ensure free and fair competition in digital markets. So these are two very important steps that have been taken as far as the competition law in this country is concerned, Siddharth. And I'm happy to go into both of those, the competition amendments that are now with the government and hopefully will be introduced in the budget session to get passed, as well as the digital competition report that we have sent. The digital competition report will be considered by government, and eventually the government will produce a bill that will be introduced in Parliament thereafter to create digital competition law as well. But the competition amendment bill is close to becoming law of the land, whereas the digital competition report is still going to go through a lengthy process before it becomes law. So that's where we are in terms of the lawmaking. But again, to step back, Siddharth, and to emphasize, the competition law framework in India is going to undergo a sea change as we put in place these new amendments to competition law and as we consider how digital competition in India should be set up and regulated.
What are the key elements, Mr. Sinha, for our audience that you could share on the key changes, like you put it, sea changes to the competition law?
Right. So first of all, Siddharth, let's recognize that the idea of competition law, not just in India, but around the world, is to ensure that there is fair competition across markets, that markets are contestable, that they're not monopolized, that various participants in markets can operate without being discriminated against, that there is an opportunity to be a partner, a supplier to firms in the marketplace. And then most importantly, that consumer choice is maximized, consumer welfare is maximized. So these are the three reasons why we have competition law, to ensure that markets are free and fair and that consumer choice is comprehensively served. Now, what has traditionally been the way that competition law has been used is after the fact. So suppose, there are several firms operating in a market. One of the firms engages in unfair competitive practices. It sort of goes into predatory pricing, for example. Then after that has happened, other firms in the market, consumers in the market, can come to the Competition Commission of India and say that there is a firm with market power, with dominant position in the market that is engaging in predatory pricing. So this is the way in which competition law is implemented around the world, which is after the fact, after the abuses of competitive position have happened. And here, through the competition amendment bill, after 15 years, several major changes have been brought in by the government. Number one, what they have done is that they have said that once they start to look at these kinds of anti-competitive practices, there can be a negotiated settlement between the Competition Commission of India and the parties that are involved in this proceeding. So previously, we didn't have a provision for a negotiated settlement. Now we do. This is very important because this is where you can get justice, you can get remedy, and the process can be quickly done. The second is that there are several ease of doing business measures that have been introduced as well, such as how quickly you have to get opinions from the Competition Commission of India, the manner in which investigations are done. So there are several ease of doing business measures that have been brought in. And third, what has also been done has been to include the deal value threshold as a criteria for analyzing whether certain mergers and acquisitions are going to result in abuse of market power. So these are three very important changes that have been introduced through these amendments to the Competition Act. And as I said, these are happening after 15 years.
Mr. Sinha, on the point of negotiated settlements, am I to understand it, and for the benefit of a lay audience, that when a violation is found, the company can settle by paying a penalty that may be sort of determined through due process?
That is correct. And that is very, very important because today, the way the process works, Siddharth, is suppose the Competition Commission of India finds that you're abusing your market power. They can pass an order against you and restrain you from those kinds of anti-competitive practices. But the company can then appeal it to the NCLAT, which is the appellate tribunal. And again, from there on, they can also appeal it to the Supreme Court. That is their right. And that whole process can take 5 years, 10 years. As a result, the people that are getting hurt because of these anti-competitive practices, whether they're companies or consumers, will take many, many years to get justice. You have to pay a small penalty, but beyond that, you can keep on appealing the process. So by having a negotiated settlement, you can get the company that is at fault to change its competitive behavior, to pay certain fines, and then close this out much, much more quickly than going through this long appeals process. So that is a very, very major step forward. And most of the important economies around the world, UK, US, European Union, all of them have this provision where you can have a negotiated settlement of these kinds of competitive abuses and these kinds of long proceedings.
Will the fines be just a rap on the knuckle, or can we expect headlines of the sort that we see overseas, $500 million, $750 million settlement amounts? What will it be like here?
Yes, the penalties can be quite substantial, that those can indeed be negotiated.
One of my points, Mr. Sinha, before I move on to the ease of doing business, is in your own experience as someone who's been in industry and now in public life, do fines really work when it comes to big, powerful corporations as a deterrent?
They can work. And for instance, in the EU now, the fines are very, very substantial, up to 10% of revenue and so on. So they are quite sizable. And of course, they have an impact on your market cap and on your shareholders, which can create a problem for management. So that's one part of it. But perhaps more importantly, when you get into a negotiated settlement or where an order is upheld through the appellate process by the Supreme Court, for instance, the restraints on your competitive behavior can be extremely substantial. And we have seen that in some of the orders. For example, famously, AT&T was broken up, right, as part of a settlement that was done. Similarly, there were restraints placed on Microsoft after the antitrust cases against them in the US. There have been restraints on behaviors that the European Union has brought in terms of the use of data, the use of certain other services for some of the big tech companies. So these restraints on behavior can be very, very important and influential. And that's really what management tends to be more concerned about in some cases than the actual penalties themselves.
Well, this is an important point, viewers. Take note of what Mr. Jayant Sinha is saying. And this comes at a time when Meta has agreed to a settlement on the data leak that is famously called the Cambridge Analytica case for upwards of $750 million. Mr. Sinha, ease of doing business, very important point. The NDA government since 2014 has made a lot of effort in this regard. But there is this sense that one picks up that the process of approval of M&A that goes in a routine manner to CCI sometimes takes months on end. I have had people telling me the horizon is 6 months to 9 months. Will any of your recommendations, once passed into law, change that aspect besides whatever else you may have proposed?
Well, there are two or three recommendations that we've been making consistently that we think will help in terms of ease of doing business. And then, of course, there are provisions in the Competition Amendment Bill that I think will help. One, of course, is the fact that in the amendment bill, they have said that these proceedings have to be completed within a certain time frame. And by putting in these hard deadlines and forcing people to operate within those deadlines, that does create pressure to get these proceedings completed. Number one. Number two, what they have suggested also is that the DG investigation for the Competition Commission of India should be selected by the Competition Commission of India. Then, of course, that selection will be approved by the government. But by doing so, you can make sure that the investigative activities are done efficiently and in a streamlined and in a very customized manner for the Competition Commission of India. And third, there are many interpretations and definitions that are cleaned up in this competition bill as well. So, for example, what defines control, whether it should be decisive influence or whether it should be material influence. If it is material influence, how do you define material influence in a very specific way? So there are a number of definitions that have resulted in litigation or have resulted in ambiguity. Those interpretations and definitions have been cleaned up, and that will also help companies in figuring out whether they fall within the purview of the Competition Commission of India or not. So all of these changes, the timelines, the investigative powers, the capacity building within the Competition Commission of India, all of these will, of course, help in ease of doing business. And Siddharth, please recognize our goal here through these laws and through the recommendations we are providing to our important regulators, whether it's the Competition Commission of India, SEBI, or even the Reserve Bank of India, is really to strengthen them, make them absolutely world-leading regulators, because India is on track to being a $5-10 trillion economy, to being one of the top economies in the world. And to be a top economy in the world, our regulators have to be top regulators as well, because that's what provides clarity in terms of ease of doing business, that enables investments, that enables free and fair competition and consumer choice. So it's very, very important that we strengthen our regulators and make it very, very clear as to what the rules of the game are.
Mr. Sinha, before we go on to the digital report, just one last point on this. In terms of the threshold changes, what have you said in summary? Are you arguing for lowering or increasing the thresholds? Because again, my own submission here would be that perhaps not everything needs to go to CCI for approval.
Siddharth, the deal value thresholds are pretty high, 2,000 crores. The asset and the turnover thresholds are also quite high at 1,500 crores. So these are relatively large sort of acquisitions that we are talking about, number one. Number two, we've also suggested that these thresholds should be reviewed every year, just to make sure that they're in line with market reality, they're in line with inflation and so on, and that these should be notified by the government so that there's absolute clarity in the economy as to where these thresholds apply. So with both of those in place, I think we will be able to make sure that these are responsive thresholds and that everybody knows about them, that they're transparent.
Okay. Now, for the layperson, the other report that you have given, big tech, and big tech is something that every one of us, every single person who has anything to do digitally is touched by, influenced by, positively and negatively. Tell us the thrust.
Yeah, you're absolutely right, Siddharth. You're absolutely right. Big tech touches all of our lives. India has close to 700 million internet users now, 350 million of them transacting on the internet. So whether it is us sitting in a city or whether it is a farmer in a village in Jharkhand, everybody is on the internet. Everybody's lives are touched by WhatsApp, by UPI, by digital banking. In all of these cases, we have to ensure that our digital markets work in a fair, contestable way. So it's important for us to upgrade our competition law framework to ensure that they appropriately cover digital markets as well. I pointed out earlier that our competition law was amended after 15 years. And so we learned a lot in the marketplace as to how competition law should be amended. And that's reflected very well by the government in the competition amendment bill. Now, equally, we have learned over the last 15 or 20 years, Siddharth, that digital markets behave very differently from traditional physical markets. So digital markets end up with winner take all monopolistic outcomes very, very quickly. It can happen within 2 or 3 years. And that is because of the underlying reality of digital markets, where you have very powerful size effects like learning effects, scale effects, and importantly, network effects as well. And because these increasing returns to size move very, very quickly, in 2 or 3 or 4 years, you can find that you can have a monopolistic winner-take-all effect on a digital market. And therefore, the traditional way of looking at anti-competitive behavior, which is after the fact, that doesn't work very well in digital markets because these markets tip so quickly, they lead to monopolistic outcomes so quickly. So by the time you finish a 5 or 10 year proceeding, that market could have already resulted in a monopolistic outcome, and that monopoly could have choked off all competition. So we cannot have an ex post after the fact system, which is the way traditional competition law has worked for digital markets, which touch all our lives right now. It's very important, and this is, of course, the way competition law has evolved around the world as well, that instead of doing this kind of regulation of competitive behavior after the fact, that we consider doing it before the fact. And this is called ex ante regulation of competitive behavior, not ex post after the fact regulation. So ex ante regulation before the fact regulation of competitive behavior is a necessity in digital markets because they result in monopolistic outcomes so quickly.
Mr. Sinha, I was reading through some of the reportage on this, and there are 2 points which are for a wider audience, apart from what you have proposed in terms of the legal bit. Curbing deep discounts, bundling, and tying of services, as well as strict norms for data usage. Why is e-commerce and discounts a matter of concern according to you?
So let me give you 4 or 5 instances, very practical instances that all of us have to deal with. So today, if you want to get an app on your mobile phone, you have to go to an app store that is controlled by 2 companies, basically, right? So if you want to download an app, you have to go to either Apple's App Store or Google's Play Store. So that's one question of where you have to think about competitive behavior. Second instance, e-commerce site and you search for a particular good, you'll find private label products that belong to that same e-commerce site showing up first on your search. So again, there platform neutrality, you're an e-commerce site, but you're showing your own private label products first. So that's a second example. A third example is that I collect data about you from one particular service that you're using, and using that data, I start trying to get you onto another service, which makes it much more difficult for some other competitor to compete with you because you are able to use data from one service to another service, right? A good example is, suppose you were to take data from Facebook and use it for WhatsApp or Instagram, all three of which belong to Meta, of course. So that's a third example. A fourth example is if, for instance, you have to pay for something and you have to use a payment service that is belonging to one of the platform companies. So that also can be a situation where instead of using another payment service, you're forced to use the payment service of that particular platform. So these are all examples of where today in digital markets, there could be competitive practices that could border on being anti-competitive, that do not allow free, fair competition and enough innovation to happen. And here, Siddharth, I'll just explain to you a very important difference between what's called static efficiency and dynamic efficiency. So static efficiency may be that in any given year, you are getting an efficient sort of set of services. But if you restrict competition and you restrict innovation, you could also be in a situation where over 5 years, you're not getting the best possible outcomes, even though in one particular year you may get a good, efficient outcome. So, dynamic efficiency is in some ways in digital markets, because they evolve very fast, even more important than static efficiency. So, all of these have to be taken into account if we want fair and contestable markets, and we want consumers to get the broadest array of choices. And that's why digital competition has to be considered very, very differently from traditional competition in physical markets.
What will the data usage norms once implemented amount to? The reason I'm asking you is that the biggest concern that a lot of people face is that, oh, I just spoke to someone about a particular product and 2 minutes later my various social media services are pushing ads from that. So, you are being listened to, whatever you type. Is that part of it also going to be covered? And I'm deliberately requesting you to explain this for a wider audience which may not fully fathom the technical argument.
Right. So it's not really a technical issue. It's a question of how the service works. So the example that you provided, Siddharth, is about an ad exchange. Okay. So what happens is that these digital intermediaries build a file on you. And suppose you search on Times of India for a tennis racket. Okay. And then you switch from the Times of India and you go to an e-commerce site. And suddenly on the e-commerce site, you start to see lots of ads for tennis rackets. How is that happening? Well, what is happening is that, there are ad exchanges that track the sites that you're on, that track your search behavior. And then once they find that you're searching for tennis rackets, they'll give you tennis rackets on every site that you go to, because you have a cookie on your computer that's telling this ad exchange that you're interested in tennis rackets. That is a personal data issue. That's not necessarily a behavior issue. And the government is introducing a personal data protection bill to ensure that you give your consent so that these cookies can then track you and follow you from site to site. So there are ways in which you can have multiple ad exchanges that are competing for this, and that way you can have competition. So if there was only one ad exchange, that would be a competition issue. But the following of that ad from site to site to site is a personal data issue. I hope I'm making sense, Siddharth. I hope you
Absolutely. No, I'm glad that you've explained it, because it kind of explains one of the fundamental points in this regard, and also the fact that there is another law in the works, which is personal data. As we wind down this conversation, I want to ask you about the usage, what I felt, of banking industry, which is systematically important financial entities, and you have called for big tech companies to be categorized as systematically important digital intermediaries. Now, what would that mean? Is this you and the parliamentary panels trying to bring them under regulation, or are you trying to build a framework?
Well, it's obviously a framework that brings them under regulation, Siddharth, because you cannot apply these restrictions or this kind of compliance on the thousands and thousands of digital companies that exist in India. However, there are a few systemically important digital intermediaries. And when we say they're systemically important, that means that they operate across a broad array of digital markets. And therefore, they have the ability to exercise market power across multiple markets. And therefore, they need to be tracked. We need to ensure that they're not misusing their market power across markets. And so what we've suggested, which is again consistent and harmonized with what is being considered in many jurisdictions and has already been passed into law in the European Union, is that we identify a small list of these systemically important digital intermediaries. Then they are restricted upfront, ex ante, from practicing certain types of competitive behaviors. And thereafter, they have to file compliance reports indicating how they are behaving with respect to these 10 anti-competitive practices that we've identified. And at the same time, they need to have the compliance departments and the people within their companies that ensure that within the companies that they don't engage in anti-competitive practices. Knowing the financial industry as I do as chair of the Standing Committee on Finance, I can assure you that our financial institutions that are systemically important are very tightly regulated and supervised by the Reserve Bank of India and by their internal compliance departments as well. And this kind of regulation, this kind of compliance, this kind of supervision actually does work well and needs to work well when you have companies that are really important and hold public trust in their hands, are custodians of public trust. So, in the same way that when I have the money that belongs to the public, I am a custodian and I have to follow certain fiduciary responsibilities. It's in exactly the same way that when I hold the data of the public in my hands, I have to operate as a data fiduciary. So, yes, there are compliance and regulatory guidelines applied to the financial industry that can be brought over to these systemically important digital intermediaries as well.
Mr. Sinha, my final question. There would be some people who would say that this could curb innovation or free enterprise in a way in a market like India. What would you say to them?
I would say that this is in fact going to spur more innovation and more competition and highlight dynamic efficiency. Because what is the worst that can happen is with these big tech companies getting bigger and bigger and bigger, they can stifle innovation. They will not allow new business models to thrive. And by the way, this has been observed and empirically proven around the world. And it's very well known that these big tech companies practice what is called killer acquisitions, where they go in and they'll buy new technologies that seem to be very, very groundbreaking and fast moving. And they then eliminate competition, they eliminate innovation, they eliminate efficiency in the marketplace. So, from a societal point of view, we want as much innovation, as much competition as possible, which is the whole idea of the digital competition report.
Mr. Sinha, all power to you and the members on your panel who have made such important recommendations, and I personally hope that this passes into law as soon as possible, because that also is an integral part of Digital Bharat. I enjoyed this conversation very much, and thank you very much for your time, and I know our viewers would also stand to benefit from what you have shared with us today. With that, it's a wrap on the show. We'll be back. Till then, goodbye and a very happy festive season.
Who better to discuss the impact of COVID on India than